Upcoming webinars and seminars. On next Monday, September 12th, so that's a week from Monday, we're going to be giving a webinar with Chuck Wasson on insurance gaps and how to make sure that you don't have dangerous gaps in your insurances. September 19th, and I'll be speaking to the Tampa Bay Medical Manager Association Thursday, September 13th, on keeping medical practices independent. Page 4, our present webinars that you can find on our website to view at no charge are partially listed there. Page 5, our book with B&A. We donated 30 copies to the Clearwater Bar Association. You can buy one for $45. They're normally $55. Citations, if you want to learn more about the law, we have a lot of citations for you there. Leaving myself with 12 minutes now to cover the topic. So, page 7, the big news is that for powers of attorney executed on or after October 1, 2011, these will still be good. There won't be any changes needed. And also, if a power of attorney is at that state, then that's going to be fine. There will be no changes needed. But if you have a power of attorney executed on or after October 1st, 2011, you have to be very, very careful. We're going to repeat everything I say a couple of times here, but the main news is any power of attorney executed on or after October 1, 2011 in the state of Florida is probably going to have some big problems if you don't. The other big news is that if you appoint someone who is not your heir or a lawyer or a Florida licensed lawyer or a CPA or a trust company, if you appoint just somebody else and they have at any time in their lifetime served 2 other principals, then they are not allowed to charge for the service. If they charge for the service, then what they do for you is illegal and may not be. Now I'm going to go to page 9 now, and I'm going to learn by experience. We have 9 catastrophes that can happen as a result of the new Florida Durable Power of Attorney Act. The first one, which I'm going to mention later, is that a springing power of attorney will not work at all if it's signed after September 30, 2011. If I sign a power of attorney which says, I appoint Crotty Denicolo to be my capacity, and I sign that after September 30, 2011, then that power of attorney will have no force or effect whatsoever. Now, there's a question if I sign that power of attorney pursuant to Delaware law while I'm in Delaware, whether it might work, and the answer is it probably won't work, and it's not worth trying. Now, the next big change is that my power of attorney would typically say, I authorize that I by law could do for myself, and that would work under present Florida law. But after September 30, 2011, I have to initial or sign next to any provision that would allow him to, A, create a trust for my benefit, B, amend, revoke, or terminate a trust that I have prepared, C, at the end. As a matter of fact, Chris is going to give you a 5 to 10 minute bonus session on gifting, and that's how I'm going to finish in 15 minutes. Anyway, D, change rights of survivorship. If you don't have this in the power of attorney, the agent will not be able to change rights of survivorship. Next, create or change a beneficiary designation. Next, waive the principal's right to the beneficiary to be in the power of attorney document. You have to have the client sign it and initial it. Next, disclaim property or powers of attorney. So those are very important things that every power of attorney is going to have to provide for. And you're going to have to go through these with the client to see if the client wants to give each of these powers. And that's going to take more time in the conference room, more time drafting, more time explaining, and the banking industry getting into the agent under power of attorney business and being very cautious for their welfare in this legislation. Now also, when you execute a power of attorney after September 30, 2011, if you don't have 2 witnesses and a notary to each principal's signature, you do not have a valid power of attorney. Now that's witnessing and notarizing the signature of the principal. That's the person who's witness and notarize power, or have always witnessed and notarized powers of attorney, because under the Equal Dignities Law, an agent under a power of attorney can't sign a deed and can't do certain other things unless the power of attorney has 2 witnesses and a notary. But it can't hurt to update your power of attorney and to have 2 witnesses and a notary. Now, please note that healthcare powers of attorney under Florida law require giving the power. That does not apply to the financial power of attorney law, but it's just something that people will confuse, I'm sure. Also, as many of you are aware, in something called a self-proving will, you need 2 witnesses and a separate notary who's not a witness. That is not required under the power of attorney statute. Also, the next catastrophe, it would be that you would be appointed and you aren't a licensed Florida resident or CPA. I mean, you're not a licensed, and you're doing this for more than 3 people. You can't be paid for doing it. And then what you're doing, if you do it and you are getting paid, might be an illegal act. And you don't want to violate the Florida statutes there. And then the last catastrophe, I think we'll all see a lot of these, is the newspapers will have articles about the new power of attorney statute, and people who want to take advantage of other people will find folks who are maybe have some wealth and are not that, and get them to sign powers of attorney and then steal from them. So if you're a lawyer or your accountant, certainly when somebody comes in and says, I'm bringing Aunt Matilda in and she needs to sign a power of attorney, but we're in a real hurry, so we only have a couple of minutes. You need to kind of sit back and think through, number 1, am I representing the agent or am I representing Aunt Matilda? And number 2, if I'm going to witness this, how am I going to make sure that Aunt Matilda has no assets and the person took them all? Where am I going to be as the advisor who set that up? Now, page 10, we have some basic information on powers of attorney. I think everyone watching this webinar probably knows what these definitions are. You know that a power of attorney terminates when a principal dies. Now, when you file here's part of the new law, page 11. If you file for a divorce, then, and I think that if you then terminate the divorce action, you probably have to sign a new power of attorney. So there may be some people out there who will have disabled powers of attorney because they filed for a divorce and made up and didn't execute a new power of attorney. Page 12, if you initiate a judicial proceeding to prove someone incapacitated, then the powers statute, so during the pendency of a guardianship proceeding, the judge could order the power of attorney to be effective. Now, page 15, there's something called a military power of attorney, and I'm sure if you sign up for the military, it's probably one of the many benefits you receive as a military lawyer to provide you with a military power of attorney, and that power of attorney can spring, but it's subject to a lot of limitations. If you have a client in the military, they're serving our country, give them a discount, give them a new Florida power of attorney, and as opposed to trying to spring because of the military power of attorney limitations, I would consider an escrowed power of attorney. And that brings us to page 16. Now, I cannot sign a power of attorney that says that I give Crotty Denicolo the power to sign documents for me in the event of my incapacity. But I can sign a power of It's not a springing power of attorney. Now, the statute does not specifically speak to escrowed powers of attorney, but it specifically says that a power of attorney can provide that either a copy is as good as an original or that you need the original to use it. So that was the legislature's secret cure to the springing power of attorney question. So many law firms and many springing powers of attorney, I'm sorry, escrowed powers of attorney with escrow agreements. Now, something else to keep in mind is if you have a client who wants a springing power of attorney, get them to come in and sign it by September 30. We have some clients who have done springing powers of attorney for us, and we're going to have them come in and re-sign them in September so that they're fresher. If I have a client who gave me a springing power of attorney 5 years ago and still wants me to have the springing power of attorney before the end of September, as long as they understand what it means. Now, page 18, near and dear to our hearts, is the revocable trust. Clients are going to be maybe more inclined to set up revocable trusts here that would spring because you can say, I am my own trustee, I place these assets in the trust, but in the event of my incapacity, the alternate trustee is, and then that can be anyone you name. These limitations that apply under the new power of attorney statute, curiously enough, do not apply under the Florida revocable trust statute, even though revocable trusts hold a lot more assets on average than someone would act under a power of attorney for. Probably the reason for that is that people are considered to be more sophisticated in the revocable trust context. Page 19, I just want to mention, you may want to put a clause in your power of attorney as long as you're updating your form to prevent financial scams or to prevent whoever you appoint as your agent from getting mixed up in financial scams during this age of the Madoff-Perlman world. Okay, there's more information in the subsequent pages, but I wanted to cover this in 15 minutes. Provision, and Crotty Denicolo, who I've mentioned before, is going to give this provision. Thank you very much for joining us, and have a great evening. Chris?
Thank you, Alan. And as Alan had mentioned, gifting under a power of attorney requires a separate enumeration by the principal in the power of attorney, and this is something that's new under this new power of attorney law. One thing to keep in mind is that an agent can make gifts on behalf of a principal, but unless that agent is someone that's legally obligated to be supported by the agent, then gifts cannot be made unless the power of attorney explicitly authorizes that. So that's something to keep in mind here. And I'm just going to back up one slide here on slide 20. You'll see that this is language pretty much paraphrased out of the section 709-2202. One other key component to the gifting provisions is that unless the power of attorney provides otherwise, the agent can only make gifts of up to $13 annual exclusion for 2011, or up to $26,000 per year if the principal is married at the time of the gift, and plus the agent can go ahead and join in a split gift tax return for any gifts made by the spouse of the principal. And this is important because we have a lot of well-to-do clients that want to make use of this increased $5 million lifetime gifting exclusion. Then the power of attorney would have to otherwise provide, or else the agent would not be able to make gifts to take a look at and think about when redrafting power of attorney documents. Okay, on slide number 21, I've listed here the federal tax implications of agents' authority to make gifts. Now, some of this area is a little bit unsettled, One thing is for sure is that granting the agent a power to make gifts by itself is not a taxable gift so long as the power of attorney is revocable. And this goes along with the principles of a gift under state and local law in that a modification or revocation of a gift, then you don't have a gift under state or local law or even federal gift tax law. So that's something to consider. Now, if the agent go ahead and makes the gift, then you have a gift for federal tax purposes occurring at that time. And it's important to keep in mind that the gift must be effectively delivered to the donee of the gift for it to be considered as complete under state, local law, as well as federal gift tax law. And this means that clear as to whether delivery is presumed if the agent is the recipient of the gift, but it seems quite likely that that would be the case. Now, there's another issue out there regarding whether the ability of an agent to make gifts to himself or herself is a general power of appointment for gift tax purposes. Now, a general power of appointment means that the assets subject to the power would be includable in the estate of the agent. And the general power of appointment is creditors to one's estate or to the creditors of one's estate. And there's gift and estate tax considerations with that, especially if an agent serving under a power of attorney has substantial assets, and this general power of appointment would cause more assets to be included in the estate of the agent. Now, there's conflicting arguments regarding this. There is no case directly on point, and one side to the argument is that a general power of appointment for federal tax despite the fact that it may not be labeled as a general power of appointment, and some other type of nomenclature may be used in creating the power. The converse to this argument is that if the power of attorney is revocable, then the donor could revoke the agent's gifting power, and in that case you would not have a general power of appointment, because any power of appointment that's only exercisable with the consent and joinder of the principal does not mind. It's advisable to certainly draft power of attorney documents to limit an agent's power to make gifts if gift or estate taxes are concerned. With Alan mentioning earlier, we're preparing new forms for our clients to take into account this new law. It's important to make sure that the forms say what we intend, and we certainly don't want unintended tax consequences here, amongst other ramifications that could occur if the forms aren't what is intended. And that concludes my discussion of gifting. I believe that concludes our webinar, and I want to thank you for joining, and we do appreciate your attendance, and please visit our website to see other webinars that we have in the future, and we hope to correspond with some of you soon.
Chris, thank you very much, and all of you who have attended, we appreciate any questions, comments, or suggestions you might have. We will be scheduling one of these for about a week and a half